paramilitaries operating in collusion with the British government. This has been a 35-year cover-up. There is no statute of limitations on murder, and there is no statute of limitations on exposing cover-up. The British government is yet to provide accountability, justice, or any semblance of closure. Yet 2 months ago, on September 11th, the Secretary of State for Northern Ireland announced that he had, quote, decided to establish an independent inquiry into the death of Patrick Finucane under the 2005 Inquiries Act, and that the government will seek to appoint a chair of the inquiry and establish its terms of reference as soon as possible, close quote. Geraldine, John, Catherine, and Michael will provide an update to the commission since September, and of course, any time before that, of course, because they have been absolutely tenacious, and their long journey, arduous journey towards this inquiry, which is evidently not yet over. For 35 years, the Finucane family has steadfastly and honorably pursued an independent public inquiry into the state-sponsored collusion in this murder. Geraldine Finucane and her children, now grown, of course, successful, have left no stone unturned in their skillful, tireless legal pursuit of justice. Their admirable and unyielding dedication to truth and justice in the face of tremendous government and paramilitary opposition rightly reflects the work and legacy of Pat Finucane and a family committed to the rule of law. The underlying issue here is collusion, that is, the British government's cooperation or connivance in or facilitation of crimes committed by paramilitaries. For decades, the British officials indignantly denied collusion. And I know because I raised it myself, as did they, of course, as did so many other people in our government and in the Irish government. They always denied it for years. When after the Good Friday Agreement, the evidence of collusion became massive and irrefutable, the British government changed tact. It admitted collusion and sometimes apologized, but sought to avoid providing any real accountability, punishing the guilty or making specific admissions. The murder of Patrick Finucane was one of the worst instances of collusion, which by all accounts was obvious, shocking in its direct aggressiveness, and went right up the upper levels of the British government. In 1998, as we all know, the Good Friday Agreement, one of the most outstanding diplomatic achievements of recent decades, left a number of issues unresolved, including the issue of British collusion in paramilitary crimes. In 2001, however, the British government and Irish governments dealt with this in negotiations at Weston Park. There, the British government assumed a solemn obligation to initiate a full independent public judicial inquiry into Finucane's murder case and 5 other crimes, if so recommended by retired Canadian Supreme Court Justice Peter Corey. On May 5th, 2004, Justice Corey did recommend a public inquiry in the case of Patrick Finucane, and frankly, he released his recommendations at a breakthrough hearing that I chaired, at which Geraldine was also our distinguished witness. Judge Corey said that there is evidence that would warrant the holding of a public inquiry, closed unquote, and he reviewed massive and multifaceted evidence of British government collusion. This was a phrase Judge Corey repeated many times. To date, the Finucane murder remains the only case Judge Corey investigated where his recommendations have not, I say again, have not been honored. This is deeply unsatisfactory for many reasons, but not the least of which is because it is likely that it's the one where the government is probably the most culpable. The Finucane murder is also a case in which, until the Prime Minister's apology in 2011, that there has been the greatest level of sustained official denial and obstruction by various state agencies. Obstruction went to such a point that rather than provide the promised inquiry in 2004, the British government prepared new legislation governing inquiries. I remember reading the bill. I couldn't believe it. It was designed to obfuscate and to deny true accountability. Total subterfuge. Though the 2012 Prime Minister Cameron acknowledged and admitted, and this is his word, shocking levels of collusion between state and loyalist paramilitaries in the murder of Patrick Finucane, this does not substitute for the full exposition of the facts behind the British state's involvement in the murder of Patrick. Rather, the steady increase in the amount of evidence being revealed publicly that senior officials in the British state colluded in the murder has made honoring that commitment more important than ever before. The many previous denials and the time that has passed in the Finucane case has drained public confidence in the peace process and diminished respect for the rule of law in Northern Ireland. It must be said that there are those who oppose the peace process, and their opposition is dangerous. The failure to address the case of Pat in the manner provided by the British government provides a readily available propaganda tool for those who would abuse it and to further that for their own ends. Congress has long supported the Finucanes in their quest for justice. Many members of Congress, both sides of the aisle, have spoken out repeatedly here in Ireland, in House of Commons and in London, and we will always support you. The House has passed 2 resolutions which I authored, urging the British government to establish a full, independent, and public inquiry into Finucane's murder. For example, in 2007, the House and then the Senate passed my legislation, H-Con Res 20, calling on the British government to deliver on their commitment to implement a public, independent, judicial inquiry into the murder of Patrick Finucane. The year before, in 2006, the House passed a resolution, H-Res 740, which specifically called, again, for the establishment of a public inquiry. Again, total bipartisan support, with support of the executive branch, and yet we have not had it, and maybe we're on the verge of that now. The Congress also passed, and the President signed, my legislation that restricted U.S. training and exchanges with the former Royal Ulster Constabulary, and to establish and to specifically include, we put it right into the text, and it became law, that those RUC officials who may have had any role in the murder of Patrick Finucane or Rosemary Nelson, who we also had testified, she was brutally killed, assassinated, that they not be allowed to participate in that very important FBI training. They are excluded, and that was the law. This is the 21st congressional hearing that I am chairing on justice issues in Northern Ireland, and the 11th at which a member of the Finucane family has testified about the family's quest for the inquiry. In 1997, my first hearing on the issue of peace and justice in Northern Ireland, Michael Finucane told our committee, "I am not seeking revenge, I only seek the truth. The memory of my father and the courage he displayed in doing the work he did deserves nothing less. Our family and I can fully reclaim our shattered lives. We ask that the British government conspiracy behind the murder of Patrick Finucane be investigated and exposed." Geraldine and John had offered similar, equally compelling and moving statements time and time again in the European venues as well as at the United Nations and here and at those hearings. In 2020, over 23 members of the U.S. Congress, including my good friend, Co-Chair McGovern, joined me in writing to the British Prime Minister, again urging him to establish an independent public inquiry into the murder of Patrick Finucane. We have tried, and I do hope that we're on the verge of success, of finally getting the full and unvarnished truth. Again, I'd like to yield to my good friend and colleague, the co-chair, Jim McGovern.
Well, thank you very much, and good morning, everybody. I join Co-Chair Smith in welcoming everybody to today's hearing on accountability for crimes committed during the Troubles in Northern Ireland, and specifically for the murder of Irish barrister Patrick Finucane. I want to thank Co-Chair Smith for his many years of leadership on this and so many other human rights issues regarding what has occurred over the years in Northern Ireland. I also want to extend a special welcome to the 4 members of the Finucane family, Geraldine, Michael, Catherine, and John, who will speak today about their decades of struggle to ensure justice for Patrick. We are privileged and honored that all of you are able to be here today. Patrick Finucane was a human rights lawyer who represented supporters of a united Ireland who had been accused of terrorism offenses. His clients included high-profile members of the Irish Republican Army, and he was extremely effective. That fact earned him the anger and enmity of loyalists and their allies. On February 12, 1989, a Sunday, he was murdered in cold blood in his home in North Belfast in front of his wife and his children. He was shot point blank 14 times. His family has been pursuing justice ever since. Specifically, for years, the Finucane family and human rights organizations in Northern Ireland and around the world have demanded that the government of the United Kingdom convene a full, independent public inquiry into Patrick's killings. Why? Because full accountability requires knowing not only who carried out the killing, a member of the Ulster Defense Association was convicted of the murder in 2004, but whether and to what extent there was state collusion in Patrick's murder. Previous official investigations, including the 2012 De Silva report, have suggested that the UDA did collude with state security forces, specifically the Royal Ulster Constabulary and the British Army. Anytime there is suspicion of state collusion with the death, a higher degree of scrutiny is required because states have an obligation to protect their citizens, not kill them. The UK is a state party to the European Convention of Human Rights. In response to legal challenges brought by the Finucane family, UK and Northern Ireland courts have repeatedly found that the government's failure to conduct an independent public inquiry on Patrick's case was a breach of its obligations under Article 2 of the Convention. The latest court ruling issued last July gave the government a deadline to deliver an investigation of the case that will be compliant with Article 2. And so finally, last September, the UK announced that it will hold a public inquiry. I hope that that's positive news, albeit it's long overdue. Of course, the devil is in the details. As somebody who is of Irish descent, as somebody who respects a positive relationship with the British government, I sincerely hope that the UK government will make sure that the public inquiry is fully independent and empowered to examine all the circumstances leading up to and following Patrick's murder. I think it would be a grave mistake to delay accountability any longer. National security is not served by states going rogue. National security should never be invoked to cover up human rights crimes. So let me close by saying how much I admire the Finucane family and the many human rights organizations in Northern Ireland and beyond that have supported their cause for so many years. We are living in very difficult times. Instead of protecting human rights, governments of all stripes are trying to roll them back. But in Northern Ireland, those fighting for justice and accountability for the brutal crimes committed during the Troubles have not given up. And they are an inspiration to us all. And let me also recognize the work done by the Bipartisan Friends of Ireland Caucus in this House, co-chaired by my colleague from Massachusetts and my dear friend, Congressman Richie Neal, as well as Congressman Chris Smith. And I'm proud to be a member. The caucus has long engaged in the Finucane case and has regularly called for justice for all the victims of violence during the conflict. And Mr. Chairman, without objection, I'm submitting for the record written testimonies from Brian Dooley of Human Rights First and Andre Murphy of Relatives for Justice. Thank you. I yield back.
Thank you, Co-Chair McGovern. I'd like to yield to the Chairman of the Co-Chair of the Friends of Ireland, Richie Neal, gentleman from Massachusetts.
Let me thank the two co-chairmen of the committee for keeping this issue of Pat Finucane's murder in front of the American people. For 35 years, I've been part of the Finucane story in trying to keep this going. Pat Finucane was a prominent human rights lawyer in the north of Ireland. While he was known for defending high-profile clients that included the Irish Republican Army during the Troubles, he also defended a number of unpopular causes, as attorneys are supposed to do. It often brought him into conflict with the British government and with loyalist paramilitaries. Pat Finucane was murdered on February 12th of 1989 in front of his family at his home in North Belfast. He was shot 14 times by masked gunmen from loyalist paramilitary group, the Ulster Defence Association. The attack shocked the public and became a focal point for allegations of state collusion in loyalist killings. The American dimension in keeping this case and others alive has been indispensable. Evidence suggested that British intelligence agents and police officers, they had this information with the UDA, and police were removed from the neighborhood when the assassination took place. Former Canadian Supreme Court Justice Peter Corey, he recommended a public inquiry into the case in 2001. In 2004, the British government announced plans for an inquiry but delayed implementation. A report by Sir Desmond De Silva found, quote, shocking levels of collusion between the state and Finucane's killers, but stopped short of implicating the government directly. On September 4th of this year, I wrote once again to Prime Minister Keir Starmer, advocating for the repeal of the legacy legislation that was enacted by the previous British government, and I believe that they intend to entertain those requests. The Good Friday Agreement brought around a series, I think, of basic understanding of what had gone awry, in some cases for 800 years, 300 years, and certainly for 30 years. I was pleased that Northern Ireland Secretary Hilary Benn indicated he would open up an inquiry and talk with Geraldine Finucane a number of times in the run-up to that announcement. But let me also say something else, why your work is that important here. I've been involved in these cases for close to 40 years, from the time of the hunger strikers and Bobby Sands. Let me just recite some unpleasant memories. Rosemary Nelson, human rights lawyer, murdered in her car. How about the cases of Gibraltar? How about the Birmingham 6? How about the Guildford 4? And Bloody Sunday. I talked to those families on the day that Prime Minister Cameron announced that there had been no part of collusion with the Irish Republican Army and those families on the Bloody Sunday march. And the apology was important, but it also needed to recognize what had really happened on that day. Those innocent people who participated in a civil rights demonstration, they were murdered by British soldiers. And only for the sake of acting upon an opportunity to seek some justice for family members. Say something about these families. They weren't looking for remuneration. They were not looking for money. They wanted an acknowledgement as to what had happened to their loved ones. This is an ugly story about collusion. And the fact that you keep this in front is really, really important to all of us. But Geraldine Finucane, quiet, persevering, and persistent in having all of us understand precisely what she witnessed in her own living room on this day at a family dinner. So this case, I'm pleased that you're staying with it. We've been at this regularly for all of these decades, and the fact that the Finucane family, who I'm going to meet with later on this afternoon when they come by, is largely based upon what we in the United States have continued to pursue in keeping this evidence out there for the British government to rightly conclude was a political assassination. So I want to thank you both for doing this and keeping this with us. And I think, once again, the prominence of this case demonstrates that when America says something about these human rights violations, that the rest of the world has a chance to listen. And now we need to make sure that the British government, with the legacy issues and the Finucane case, remain with us. And if I might, Mr. Chairman, say the following. I also think Raymond McCord's case should be taken up. And Raymond McCord, his dad, has spoken to me many, many times. I don't think I'm divulging a secret when I point out that he was from another tradition in the North. Jerry Adams asked me to take up the McCord case as well, because he thought that it was important for us to demonstrate an interest in violations that had taken place in both traditions in the north of Ireland. So I hope that you're going to continue with your great work on this, and I'm indeed, professionally and personally, very grateful for what you've done, the two of you. Thank you.
Thank you very much, Richie, for your very fine statement and leadership. You know, we did have McCord testify at one of our hearings, and I agree with you. You know, we're against collusion, murder, terrorism, and it came out in that hearing, and I agree with you, so we will continue that, and I thank you. I'd like to yield to a member of the Executive Committee of the Lantos Commission, Dr. Andy Harris.
Thank you very much, Mr. Chairman. I want to thank the co-chairs for keeping this issue on a front burner. 5 years ago, I visited Northern Ireland with traveling with the Helsinki Commission, and we met with members of the family. And at that time, you know, there was hope that maybe after 30 years at that time that something was going to be done, but I guess not. As Mr. Neal says, suggests persistence is obviously necessary, and we're demonstrating that we're going to be persistent here at getting to the facts here. And again, that's all I want to say, because I want to hear about an update from the family over the past 5 years since I had the opportunity to visit. Thanks. I yield back, Mr. Chair.
Thank you very much, Dr. Harris. I'd like to now introduce our distinguished panel, who really does not need introductions, especially Geraldine for her heroic, persistent, tenacious, and what a class leader for human rights. She is just amazing. Everybody knows that she was there, obviously, when her beloved husband was murdered, as well as the rest of the family. But she and Patrick were both undergraduates of Trinity College in the late 60s. They were from different parts of divided society. The couple married in Dublin and returned to Belfast to start a family. Geraldine qualified as a teacher and worked in the education system for over a decade until she left to join her family title search company. She is now retired and divides her time between her beloved grandchildren, her beloved horses, and campaigning internationally, again, for an international inquiry into the murder of her beloved Patrick. Michael Finucane is the eldest son of Patrick and Geraldine. He practices law in the city of Dublin, where he now lives. He is a law graduate of Trinity College, established his law practice in Dublin in 2004. He's currently a member of the Irish Human Rights and Equality Commission and formerly chaired the Human Rights Committee of the Law Society of Ireland. He has been involved in human rights activism both in the north of Ireland and the Irish Republic for over 30 years, and the father of 2 children. Catherine Finucane is the only daughter of Patrick and Geraldine. She lives in Belfast in the north of Ireland with her husband and teenage daughter, having lived previously in France and Galway after her graduation from the University of Ulster. She works as a psychological counselor and youth worker in North Belfast area. And then we'll hear from the Honorable John Finucane, who's the youngest son of Patrick and Geraldine. He studied law at Dundee University after qualifying as a solicitor, established his law firm in Belfast in 2014. Is qualified to practice throughout the island of Ireland, as well as in England and Wales. In 2019, he was elected to Belfast City Council and became the Lord Mayor of Belfast. Later that year, he was elected an MP for North Belfast, a position he retained in the UK general election in July of 2024. And again, I want to thank you all for being here. We will all follow up aggressively on what we hear, and I'd like to yield whatever time she would like to Geraldine Finucane.
Mr. Chairman, members of the Commission, my fellow speakers, ladies and gentlemen. My name is Geraldine Finucane. My husband was Patrick Finucane, the Belfast solicitor, murdered by loyalist paramilitaries in 1989. My family and I have campaigned since his murder for an independent public inquiry into the circumstances surrounding the killing. We have done so because of compelling evidence that my husband's murder was part of an approved British government policy of widespread collusion between the state and loyalist paramilitaries, which incorporated state complicity in all types of illegal activity up to and including murder. On the 11th of September this year, 2024, the British Secretary of State for Northern Ireland announced in the House of Commons that an independent statutory public inquiry would be established into the murder of Pat. After 35 years of campaigning for such an inquiry, this announcement represented a significant step forward for my family in our fight to uncover all of the circumstances behind Pat's murder. It has been a long journey to get to the point where the establishment of a public inquiry has finally become a reality, and I look forward to having the opportunity to participate in a statutory inquiry and expose publicly the whole truth behind the murder of my husband. This has always been the objective of the campaign that my family and I have pursued for 35 years. We have only ever been concerned with uncovering the truth, and it is this that has kept us going. It is the central element that has been missing all these years, no matter how many small pieces of information were revealed along the way. Nothing less than a complete picture would suffice. We did not believe that Pat's murder was simply the work of gunmen who killed him. It was and is clear that there were many other participants who helped to carry out and implement the scheme. Loyalist paramilitaries were not capable of devising and realising a plan to murder such a high-profile target without significant help. The information that has come to light throughout the course of our campaign demonstrates clearly that they did have such help and that it came from British state sources such as Army Intelligence, the Security Services of MI5 and the Royal Ulster Constabulary Special Branch. When all of this is taken into consideration, it is not surprising that we had no confidence as a family that mere police investigations would ever bring those responsible to justice. We were also not satisfied with private, limited reviews established by the British government, from which we were excluded. We could not and did not accept the assurances of previous British governments that they were anxious to set the record straight, because they were never prepared to do so in public. An independent statutory public inquiry is and was the only way to bring the whole truth behind the murder of Pat Finucane into the light of day. And we look forward to this new chapter in our campaign, where we engage with an independent chairperson of an inquiry, discuss and agree terms of reference, and start to review the evidence that the inquiry will consider and the witnesses whose testimony will be heard. The journey to this point is not one that my family and I have had to endure alone. Indeed, we would never have succeeded without the assistance, support and encouragement of so many people over the years. Pat's business partner, Peter Madden, from the firm of Madden and Finucane, which they founded together, the many lawyers who have represented us in countless court proceedings over the years, all were invaluable to our campaign. The time and effort they gave to our cases went far beyond the extent of representation that should be required of any advocate, and yet it was given without complaint time and time again. I would like to express my gratitude to all of them for the record. Many human rights NGOs at home and abroad raised our case again and again in forums as diverse as the European Commission, the United Nations, and of course, these Houses of Congress. They made sure that the seriousness of the case became and remained of concern internationally. Organisations like British Irish Rights Watch, the Committee on the Administration of Justice, Relatives for Justice, Amnesty International, the Pat Finucane Centre, Human Rights First, the Brehon Law Society, the Ancient Order of Hibernians, and many, many others raised the importance of this case continuously and tirelessly, so that successive administrations and policymakers understood its importance and kept it on the agenda. This was not easy, but the commitment to our case by every organisation who helped us never wavered. I would like to record my gratitude and that of my family to each and every one of them for the record. As I sit here with my family before this committee, I am reminded of the unwavering support we have received from the United States and its congressional representatives over many years. The first congressional hearing on human rights in Northern Ireland took place here in Washington, D.C. on the 24th of June, 1997, before the Subcommittee on International Operations on Human Rights. A then unfamiliar congressman called Christopher Smith from New Jersey chaired that meeting, which was attended by my son Michael and others from Ireland and the United States. This was a year before the signing of the Good Friday Agreement and 4 years before the Western Park negotiations. It would be another 27 years before a public inquiry into Pat's murder would be announced. In that time, many other hearings were convened by Congressman Smith and others, some of whom are sadly no longer with us. Not only does this include members of this House, but also speakers at the hearings themselves. During the course of the journey towards a public inquiry for my husband Pat, another Irish solicitor, Rosemary Nelson, was murdered by loyalists in 1999. Allegations of threats by police and collusion with paramilitaries were yet again continuing hallmarks of this murder, just as they are for Pat. Rosemary herself testified about the threats and intimidation she faced in a hearing like this one in this House in late 1998. An inquiry into her murder has concluded, and the establishment of that inquiry would not have been possible without the stalwart efforts of Congressman Smith, his staff, his colleagues, and all those in this House who value justice and the rule of law. I thank you all for this. The inquiry into the murder of Pat Finucane is the last remaining case of those promised at the Weston Park negotiations in 2001. Many have described it as potentially the most controversial of all inquiries and the one that could cause the greatest embarrassment for the British government. The UK Supreme Court in 2019 began its judgment on this case with the words, and I quote, "This shocking and dreadful event still ranks 30 years later as one of the most notorious of what are euphemistically called the Northern Ireland Troubles." End of quote. Notwithstanding this, I believe the inquiry can be a watershed moment in the difficult subject of legacy on our island. If an inquiry into the murder of Pat Finucane can finally examine publicly all of the collusion that plagued our society for so many years, there is hope that the real process of healing can begin. The murder of Pat Finucane is the last remaining Weston Park case. It is high time it was properly investigated, publicly examined, and finally resolved. I believe that my family deserve this after so many years. Pat deserves this after so many years. And Irish society as a whole deserves this after so many years. After 35 years of cover-ups, it is time for truth. I thank this commission for its time today and the opportunity to speak and to be heard.
Geraldine, thank you so very much for that moving testimony, and above all, for the work that you have done all these decades. It inspires all of us to action. Again, you're not just a woman of class and strength, but your persuasiveness is it's contagious. I thank you so much, because we're only here today because of your work and that of your family. Michael?
Thank you, Co-Chairman Smith, Co-Chairman McGovern, members of the Commission, ladies and gentlemen. I'm Michael Finucane, the eldest son of Patrick Finucane. My family and I have campaigned since his murder in 1989 for an independent public inquiry into all the circumstances surrounding the killing. As my mum Geraldine has just testified, this has been a long and difficult journey for the family, but we have persevered. It would seem now, at long last, that an inquiry is imminent. We began the campaign for an inquiry almost immediately after my father's murder in 1989 because of the highly suspicious and controversial circumstances surrounding the killing. My father had been the subject of threats, including death threats, from the RUC for many years before his death, and had experienced a great deal of hostility and obstruction throughout his practice as a lawyer. Shortly before his death, an allegation was made by a British government minister called Douglas Hogg in the UK House of Commons that there were, quote, in Northern Ireland a number of solicitors unduly sympathetic to the cause of the IRA, close quote. This was believed at the time to be a statement that increased the likelihood of targeting defence lawyers who were already working under very difficult conditions in Belfast and elsewhere. It was made only 3 weeks before my father was killed. The reason we campaigned for a public statutory inquiry is because there was no other mechanism that was capable of establishing and exposing publicly all of the circumstances surrounding the murder. It has been described as one of the most shocking events in over 30 years of conflict, and yet, to date, remains unresolved. The history of the conflict in the north of Ireland is littered with examples of unresolved murders. While many killings by paramilitaries were investigated and persons prosecuted, the consistent experience of many people whose relatives were killed by the RUC, British military personnel, and, in many cases, loyalist paramilitaries, was one of little or no investigation and minimal accountability. Not only has this been a feature of our case, but it was also a recurring feature of many cases in which my father was retained as a lawyer on behalf of bereaved relatives. In February 2019, the UK Supreme Court gave its judgment in the case brought by my mother against the United Kingdom. This was the culmination of litigation that had been commenced in the High Court in Belfast in 2011. The judgment cited an extract from a report prepared by a British government lawyer, Sir Desmond de Silva, in 2012. And in his report he said the following: "I am left in significant doubt as to whether Patrick Finucane would have been murdered by the UDA in February 1989 had it not been for the different strands of involvement by elements of the state. The significance is not so much that the murder could have been prevented, though I entirely concur with this finding. The real importance, in my view, is that a series of positive actions by employees of the state actively furthered and facilitated his murder, and that, in the aftermath of the murder, there was a relentless attempt to defeat the ends of justice. My review has left me in no doubt that agents of the state were involved in carrying out serious violations of human rights up to and including murder." Although the conclusions of the De Silva review were forceful and carried impact, it was a limited investigation process and left many questions unanswered. Many aspects were not pursued to a conclusion, and key witnesses were not questioned. Ironically, this was exactly the type of problem faced by my father during his lifetime in difficult and sensitive cases, one of which ultimately led to profound changes in the law many years after his death. This particular case occurred as a result of events in November 1982, when 3 men were shot and killed by a specially trained unit of the RUC in a rural area of Northern Ireland just outside Lurgan in County Armagh. None of the men were armed. One was shot in the back, and the police officers involved in the operation expended nearly 200 rounds of ammunition when they opened fire on the vehicle the men were travelling in. It was a case that generated a great deal of controversy. It did lead to a prosecution of the officers involved, to my knowledge the only one of its kind that's ever taken place in Northern Ireland, but the officers were acquitted at trial, despite evidence of perjury and manipulated testimony. Following the controversy of the circumstances underpinning the proceedings, the acquittal was also highly controversial, not least because of the final comments made by the trial judge, who summed up the evidence in the case and concluded by saying, "I consider that in fairness to the officers, that finding also ought to be recorded together with my commendation for their courage and determination in bringing the 3 deceased men to justice. In this case, the final court of justice." Close quote. My father became involved as the legal representative on behalf of one of the relatives of the deceased men. The criminal proceedings having concluded, the matter proceeded to an inquest, which was significant because it afforded the relatives of the deceased their first opportunity to explore the circumstances surrounding the killings. One of the driving factors was that none of the police officers responsible for or involved in the shootings of the men were obliged to appear at the inquest, where the first opportunity would be given for cross-examination. Instead, the law at that time permitted them to rely on pre-prepared written statements. My father challenged this successfully in the domestic courts and won an important legal precedent before the Northern Ireland Court of Appeal in 1990. This precedent would later be overturned by the House of Lords, and this brought the case eventually to the European Court of Human Rights in Strasbourg. The court eventually delivered a ruling that would alter the landscape of investigation into fatal incidents in a profound and radical way. 4 cases were decided by the European Court of Human Rights in 2001: McCare, Jordan, Kelly and Shanahan. All of them were challenges to the way in which investigations were conducted, including the gathering of evidence, interviewing witnesses, presentation of findings, and final amenability to public scrutiny. The court examined the practices and procedures in all of the cases and heard from lawyers for the deceased and the UK government. The cases were groundbreaking. They had the potential to set a huge precedent for all forms of investigation in the future where the state was responsible for or implicated in a death. 2 of the 4 cases were presented by my father's law firm, Patrick Finucane. Although the Jordan case dated from 1996, the McCare application was the very same case that my father had begun in 1982. It continued through many years and many layers of court proceedings for 19 years before reaching Europe. This quartet of cases delivered a seismic shift in the way investigations would be conducted going forward. The European Court was critical of the manner in which investigations in the 4 cases had been conducted, and in particular, the way in which the relatives of the deceased had been forced to fight for every scrap of information they obtained, and also to be included properly in public hearings. In future, investigations would have to conform to minimum standards in order to be human rights compliant. If they did not, a violation of Article 2 of the European Convention would follow. The court stipulated that investigations had to be, firstly, reasonably prompt, secondly, verifiably independent, thirdly, effective in the way they operated, fourth, public and amenable to public scrutiny, and finally, that they would ensure involvement of the next of kin and family to the maximum extent possible. These rulings did away with the practice of police investigating the police with impunity. Officers would now have to appear and give evidence and be available for cross-examination. Documents and forensic reports would have to be made available promptly. Public hearings would have to take place, and above all, investigations had to be capable, at least, of reaching meaningful and effective conclusions. No longer would those responsible be immune from prosecution or redress. Impunity was at an end, at least as far as the system was concerned. A new landscape had been created, and it would not be long before all agencies of the state realised they would have to alter their practices or risk being found in violation. The shorthand description for a lawful investigation going forward would be Article 2 compliant, and this flowed directly from the cases brought before the court. During the course of its ruling on our case in 2019, the UK Supreme Court stated as follows: in deciding whether an Article 2 compliant inquiry into Mr. Finucane's death has taken place, it is important to start with a clear understanding of the limits of the Silva's review. His was not an in-depth probing investigation with all the tools that would normally be available to someone tasked with uncovering the truth of what had actually happened. He did not have the power to compel the attendance of witnesses. Those who did meet him were not subject to testing as to the veracity and accuracy of their evidence. A potentially critical witness was excused attendance. All of these features attest to the shortcomings of the review as an effective Article 2 compliant inquiry. The tentative and qualified way in which De Silva has felt it necessary to express many of his findings bear witness to the inability of his review to deliver an Article 2 compliant inquiry. It is therefore unsurprising that on the 17th of May 2011, the NIO prepared a memo where it was accepted that it would not be Article 2 compliant. In the court proceedings, the Crown claimed that if the review was taken with what had gone before, then it did fulfil the requirements of Article 2. For the reasons that I have given, I do not accept that submission. Close quote. In 1982, and even in 1989, the phrase Article 2 compliant inquiry had not yet come into being. But the foundations for it had been laid by the very man whose murder would, one day, be fully investigated because of it. This is perhaps one of the greatest ironies of the life and work of Pat Finucane. The efforts and innovations of his lifetime would be the very thing that ensured the circumstances behind his own murder would not remain hidden. What happened to him has been described by some as a life lost for the law. I think it more apt to say a life given for truth. a high price indeed. Pat Finucane began an important challenge to the system in which he worked so as to expose how it was depriving people of truth and covering up wrongdoing. It did not matter to him that it would be very difficult to achieve or that it would take a long time. He was a determined man and he was resolute. It appears to be a family trait. The truth has been a long time coming, but my father would, I think, have wanted us to stay the course. With the great help of our friends here in America and around the world, I believe we have done so. I would like to thank this commission also for its time today and the opportunity to speak and be heard.
Thank you so very much, Michael, for that very detailed set of insights into the legal process, and couldn't thank you enough, and appreciate it. And going back to late 1980s, 90s, I should say, when you testified, I mean, that was, and Jolene, you as well, that was the springboard for all of us to do even more. So I can't thank you enough. I'd like to recognize Catherine Finucane.
Mr. Chairman, members of the Commission, my fellow speakers, ladies and gentlemen. My name is Catherine Finucane. I am the daughter of Patrick Finucane, who was murdered by loyalist paramilitaries in our home in Belfast in 1989. My family and I have campaigned since my father's murder for an independent public inquiry into the circumstances surrounding the killing. The Swiss-American psychiatrist Elizabeth Kubler-Ross said, "The reality is you will grieve forever. You will not get over the loss of a loved one. You will learn to live with it. You will heal and you will rebuild yourself around the loss you have suffered. You will be whole again, but you will never be the same again. Nor should you be the same, nor should you want to." The brutal way in which I lost my father added another dimension to our grief. My father was very well known for the work that he did as a lawyer, and many people relied on him in the fight for equality and human rights. The public nature of his murder meant that we grieved along with our society. It has not been resolved, and the consequences are many. My dad, in his work as a solicitor, was an advocate for the community. My brothers continue that work, and my role in mental health is a branch of that work. We are of him, and he has inspired us to be who we are. We did not have him for long in our lives, and although we have our memories, we were robbed of so many more. When my young daughter asks me, "How did Granda Pat die?" I am reminded that the past is now moving into yet another generation. Now 14 years old, she asks me, "Mummy, what would Granda Pat have thought of me? Tell me what he was like." It wasn't only my brothers and me who had their father stolen from them, but our children too. So I tell my daughter what her Granda was like. He liked to play football and didn't like to lose. He liked a joke and a laugh and often played practical jokes on his siblings. He inspired me to learn the French language, and I listened to him asking for directions on our family holidays in France. And I tell her, he would have loved her very much, and they would have had the best of fun together. Having been told for so long to move on and draw a line under the past, the recent announcement of an inquiry has provided us with much hope that we will finally get the full picture of what happened and get the answers as to why my father was murdered. We can only move into the future when we have a clear sense of the past. Our fight for justice has not only been for my dad, but for a future fit for our children, and one that he would be proud of. We have high expectations that the upcoming inquiry will provide that. I would like to thank this Commission for its invaluable time and support shown to my family over so many years. Thank you very much.
Thank you very much, Catherine, for your testimony and for being here today, and for bringing focus on the mental health side of all of this through your work. And thank you, and your witness. I'd like to now recognize the Right Honorable John Finucane, a colleague, and appreciate his work as well.
Thank you. Co-Chairs Smith and Co-Chairs McGovern, may I also begin by extending my deepest thanks and gratitude for convening today's Commission hearing and the invite to us all to attend and testify before you. Whilst we have all at some stage either met with you or testified before you, today represents, certainly to the best of my knowledge, the first time all four of us have appeared beside one another, and I thank you for that. For we are here in America in very different circumstances than you will have been used to seeing us. After over 35 years, we have finally listened to a British government publicly announce that they will establish a public inquiry into my father's murder. Indeed, it has been a long road to achieve that, and we know we have a considerable journey still to travel as we set out to ensure the inquiry is both credible to us and also to those who have supported us over the years. This recent stage of our journey can be traced back to our victory in the UK Supreme Court in January 2019, when the court found that all previous investigations had been ineffective and failed to meet the standards required under human rights law. This was significant because by that time we had had experience of different investigative vehicles over the years, from the Stevens police investigations, the Corey review and the De Silva review. Each one was not asked for or welcomed by us, and we call each of them an exercise in delaying the correct approach, which would have been the establishment of a public inquiry. Following our Supreme Court win, we were again met by deliberate inaction on behalf of the British government, and my mother was once again forced to initiate legal proceedings due to the inadequacy of the response. This led us to yet another significant endorsement by the courts when in December 2022, our High Court again recognised the absence of any effective investigation and certainly in judicial terms criticised the government's response to the Supreme Court ruling. Not surprisingly to us, but cynically nonetheless, the government appealed this ruling, and this led to our Court of Appeal in Belfast examining all of the issues once again. Whilst we were again frustrated at the delay these proceedings naturally brought, it is no exaggeration to say that when the court gave its judgment in July 11th this year, it was both crystal clear in its message and momentous in its implications. It is a lengthy and detailed judgment dealing with, at times, complicated areas of human rights law, but some extracts are worth noting. In particular was the court's clear frustration at the government's response, or indeed lack thereof, to the Supreme Court ruling. It said, and I quote at paragraph 39, "We have some difficulty in accepting the submission that the Secretary of State now requires further advice from this court about what steps he must take to ensure that any investigation is Article 2 compliant. Firstly, the instructions given by the Supreme Court were clear and comprehensive. No one should have any difficulty following them. We have set them out in some detail. Secondly, it does raise the issue, given the lengths to which Lord Kerr took to set out what was required, and given the decision of the judge at first instance, as to whether there is a genuine bona fide appeal or an attempt to procrastinate in the hope that the difficult decision of whether the state colluded in the murder of Pat Finucane will fall to be made by someone else or indeed a different government, which is now the case." The court went further again when analysing the response of the government, this time at paragraph 96, when it said, "The court is driven to conclude that whatever way one looks at what has happened, the following conclusions can be reached with some degree of confidence. 1. The Supreme Court gave clear instructions as to what was needed to have an Article 2 compliant investigation. 2. Those comprehensive instructions, for whatever reason, have not been followed, and this court will not attempt to improve upon them. 3. To date, there has still not been an Article 2 compliant investigation, and waiting until the police ombudsman process is completed in 2025 was never going to be the answer. And 5. The Secretary of State made insufficient effort to assess what further process or processes might be necessary after the police ombudsman had reported, and how this could be achieved and what the likely timescales were going to be." End quote.
So our Court of Appeal was clear. The government had not responded as they should have. There was still no effective investigation. So what was to be done? Were we going to have yet another damning judgment under our arm and hope that by now a new British government would do the right thing? And it is in this context, it is the court's directions which proved so significant. Having excoriated the government's position, they directed that the government must find agreement with our family within 3 weeks on what an Article 2 compliant process would look like. In the absence of agreement, both parties, the government and ourselves, would submit what they felt was the best Article 2 compliant process, and it would then be to the court to direct which one would be established. Just 1 week after the British general election and a day before a significant holiday in the north of Ireland, the significance of this was perhaps lost on the media and others, but certainly not ourselves, for it is exactly this judgment which we believe has led to the British government realising that they must finally establish an inquiry when they made the announcement to the House of Commons on September 11th. So this is where we now find ourselves, in unfamiliar but welcome territory. We are no further on with regards details of an inquiry from the announcement itself, but this is not necessarily something we criticise, for we want to see that everyone is committed to doing this correctly rather than expeditiously. Our focus, and indeed the focus of those who have supported our call for an inquiry, must now be on ensuring this process is credible, transparent, and capable of gaining the trust and endorsement of those who have recognised its need. My mother and I were asked just last week what we wanted from an inquiry, and indeed this is something which we are all giving deep thought and consideration to, but some points I would say are obvious. We want an inquiry to be independent from government and free to make its own determinations and recommendations. We feel that this inquiry needs to be led by an independent judicial panel, complemented by the key appointments to an inquiry, such as counsel to the inquiry, solicitor and secretary to the inquiry, also being independent and committed to ensuring the terms of reference are implemented and followed fairly and sensibly. Terms of reference, which I have just mentioned, are also critical. We look forward to engaging with the British government and indeed the inquiry itself on these, for they will be crucial in determining from the outset the inquiry's ability to examine all of the circumstances leading up to and following my father's murder. We know that collusion existed. We know it was widespread, and we have had a British Prime Minister apologise for this. However, we will meet this inquiry with no preconceived expectations. What we want is what we have always asked for, and that is something which is fully independent and transparent and capable of finding out all of the details as to what happened and ensuring recommendations are made to ensure the policy of murdering your own citizens is never allowed to happen again. As with all stages of our campaign, this is a battle we know we will not be facing alone. American involvement and guardianship of our peace process has proved both pivotal and necessary at times, and so too does this apply when we look at how we are dealing with our past, and in particular the case of Pat Finucane. Now more than ever, we need you and your colleagues being that critical friend to the British government, impressing on them not to waste or undermine this opportunity to finally examine what they described in their own words as one of the darkest chapters from their military history. We thank you again for the invite to speak with you today and your continued support up to this point and in the time ahead. Thank you.
John, thank you very much. It was great. Your testimony was outstanding and incisive. But Patrick has to be very proud of you, looking down from heaven at a family that has just excelled in every way possible and has pushed for human rights observance generally and for accountability specifically for his heinous murder. So thank you for that. You are all just such noble people, and I'm in awe of you. You know, you mentioned, mention was made of Rosemary Nelson. I did meet with her on one of several trips to Northern Ireland, and she actually was threatened by the RUC. Couldn't tell who it was because his name was covered. And we decided, and it was her thought, to come and testify. She did in 1999. And I'll never forget, one of her strongest statements she made was that no lawyer in Northern Ireland can forget what happened to Patrick Finucane. and sadly, she was assassinated soon thereafter, and which just shows no one can forget. And the legacy of impunity and killing and murder was continuing then. I'm hopeful about this public inquiry. No preconceived expectations, as you clearly conveyed to us, John. We just want to get it right, let it be transparent, let it be completely the truth, non-government, transparent, as you said. And I hope it does comport with Article 2 of the European Convention. Reasonably prompt. If you start the clock now, hopefully prompt means no thoroughness is undermined by, a rush, but they've had so many decades to get this right. Verifiably independent, effective in the way they operated, public and amenable to public scrutiny, and ensure involvement of the next of kin family, which is you. And our hope is that all of that will be realized. I plan on introducing legislation, and rather than just a simple resolution, it would be an HR, it would be a bill that would seek to truly get the State Department and the executive branch, we have a new executive branch coming into being in January, to not only understand this issue, but to monitor it very effectively, and to encourage that at long last, the British government do what is right. And I'm wondering if you have any thoughts about what the timeline next steps might be. Any of you would want to speak to that? And I will do that, Bill. I'll ask for your thoughts when we put together a draft. And I assure you we will work hard to get it passed. And I think it will be, as you saw, totally bipartisan. The British government has a chance to at least get the accountability part right at long last. The collusion is horrific. To think that, as you said, they would prey upon their own citizens, as they did, but they did. And this, let me say for the record, Jim McGovern did have to leave. He is the ranking member of the Rules Committee, and there's a bill up right now, and he has to manage it for the Democrat side of the aisle, so that's why he left. But he wants you to know how deeply concerned he is as well, as are my other colleagues. And there are others, Mike Kelly and others who wanted to be here. We will give them everything, your testimonies as well. So if you might want to speak to next steps, when you think they might be doing something, they being the government, if you have any insights there. And, with regards to the legacy legislation, last time the disappointment was numbing when all of a sudden they passed new legislation to preclude certain information from being made a part of an inquiry. That's got to be done right, and I know that it was stated that they, they want to repeal and replace the Legacy Act. Hopefully your thoughts on what that might look like. Again, transparency, the right to know, especially when a terrible crime has been committed by a government. You can't hide behind some kind of false sense of, we can't disclose state secrets. So if you might want to speak to that as well. But next steps, timeline, and legislation that we might be able to get passed here.
The precise nature of the timeline is not entirely clear at this point. The establishment of a statutory inquiry such as this does take some time to prepare, not least perhaps for preliminary logistical steps such as identifying a presiding chair over what we hope will be a multi-person panel. Our suggestion would be 3 judges, somewhat similar to the Bloody Sunday inquiry's structure, but so that different experiences and different expertise can be brought to bear on what is a wide-ranging issue, both in terms of the time period that it covers and also the various issues and the involvement of so many different British state agencies. Beyond that, the terms of reference as a matter of law are typically worked out between the government and the chairperson of the inquiry, but it is important that they listen to the various interested parties, and in our case, We are trying to highlight this to our friends and supporters so that they can echo our concerns and our interests to the British government in order to ensure that ultimately what we end up with is an effective, strong inquiry that is capable of commanding its own brief, free from outside interference, that it's not unduly influenced by vested interests, of which there are many, and that the inquiry would be capable of exploring all of the issues through the evidence and going wherever that evidence leads. And if you end up with an inquiry like that, and it's important to begin that work early so that the fundamentals are strong and in place right from the beginning. But if you do manage to do that, then I think what you do is you establish a mechanism that has a great deal of potential in terms of restoring public trust in the institutions of state that have not covered themselves in glory to date when it comes to investigating and resolving difficult and sensitive cases. The legacy issue is a very broad issue, and it affects a great many people. But a great many people take confidence from seeing other cases, in particular this case, because it is so high profile. And if they see that that is being investigated properly, then they start to believe that perhaps the issues of the past are being taken seriously, and that we have a good chance of maybe trying to move beyond them with a solid and firm social structure behind us. So it is an important case for us, but it's not a case that can really be taken in isolation from society at large, because it affects so many other things.
Just with respect to the legacy legislation, it's worth remembering that this was very cynically imposed by the then Conservative government, and it was very much part of a pattern whereby they took unilateral decisions that caused enormous damage to relations within the island of Ireland and beyond. This was a good example of that. What they achieved rather uniquely in submitting this bill, which then became the Act, was uniting every single person on the island of Ireland in opposition to it. Indeed, on the islands of Britain and Ireland, the only people who supported it were the Conservative Party themselves. They didn't really try to hide their motivation for that either. This was very much about protecting British state actors and making sure that there would be no independent examination of what they get up to. What it meant was, at the stroke of a pen, families who in some cases had been campaigning and fighting for over 50 years to get something as straightforward as an inquest were told that that inquest would no longer take place. It had been subject to legal challenge, which I will come back to, but in the intervening period, we have had a change of government in Westminster. Now, the commitment was given by the then Leader of the Opposition, now Prime Minister Keir Starmer, whilst he was in Belfast at Queen's University, that the legacy legislation would be repealed. That does seem to have evolved to tinkering with it rather than repeal. We still do not have the resumption of inquests. People's ability to take civil cases is still restricted, and people are still waiting to see exactly what it is the British government are going to propose. A mistake that was made was the endorsement of the body that comes from the legacy legislation, the ICRIR, and that had not been given a clean bill of health by our courts, but it was given a political endorsement by the Labour Party. In recent weeks, our Court of Appeal, when looking at the legacy legislation, has been very critical and damning of this ICRIR body. And what I think, in a nutshell, crystallises the opposition that people have to it is the complete lack of ability. It's similar to what we've experienced through De Silva and Corey and Stevens, the lack of any ability for families to get in and ask questions and be represented. It amounts to really nothing more than a desktop review. And when you're dealing with some of the issues and cases which you will be familiar with that arose from our 40 years of conflict, that simply isn't good enough, and it hasn't been given that Article 2 clean bill of health by our Court of Appeal. So This wasn't a problem of Labour's making. The longer they delay in not fixing this, it will then become their problem. And of course, what we've had previously, which was not implemented, was a Stormont House agreement, something which did was put out to consultation and was engaged in widely. It did have the success of having a lot of support from all sides of the community, certainly all political parties. And the failure to implement and honour agreements that were made is a recurrent theme of when you start to see slippage and mistakes made in our peace process. So, like a lot of other people, we were waiting to see what exactly the British government will do on this legacy legislation.
You spoke about the seismic change that occurred from the court cases, and the thought, and John, any of you might want to speak to this, but the case law obviously can lead to dramatic reform. Hopefully, this case of your dad's and the public inquiry will lead to recommendations for, hopefully, seismic changes and reforms in other areas. Do you have any sense of where that might go?
The cases that were decided in 2001 shortly preceded European proceedings of our own, which were decided in 2003. But it's perhaps fortunate that the original 4 cases that the court heard were able to focus on unsatisfactory elements of investigation in an issue that was not perhaps so high profile. And I say that because it would be too easy to dismiss a precedent set on the basis of a very high profile and controversial case as an outlier or an aberrant example of where things went wrong because of human error or system failure that was not typical of how things were dealt with in general. But what we know is that the system of collusion that was in place in Northern Ireland for so many years was not a case of a few bad apples breaking the rules and not being called to account. It was a program that was implemented specifically to enable the state to exercise a degree of control over paramilitaries engaged in open conflict. And then taking that one step further, the state also appears to have been able to direct the activities of loyalist paramilitaries towards certain specific targets, and Pat Finucane was one of them. What the European Court rulings did, perhaps most significantly, was to take cases from a society engaged in civil conflict and apply general standards of human rights law, notwithstanding that the British had often used the conflict as an excuse for departing from those very standards. So in simple terms, the court said, regardless of where you find yourselves, the rule of law still applies. And I think the compelling thing about the standards that the European Court set out in 2001 is that they are very clear. They can be applied mechanically in any given case. And the only thing that's really required by an investigator is resolution and courage in applying those standards and making sure that their work is effective, making sure that it's independent, making sure that it's done publicly, and making sure that family and next of kin are involved. And it's frustrating sometimes because the standards are there. They are capable of being applied in virtually any case when the will is there. And the frustration arises because you're able to present these in clear terms to, in particular, the British state, and it's their abject refusal to do so that causes so many problems.
Thank you. We will provide your testimonies to the Biden administration, but we'll also convey it to the incoming administration as well, along with the legislation, which I hope they will endorse. Let me just ask 2 final questions. One, and John, this would be to you. In the year 2000, I was the head of delegation for the OSCE Parliamentary Assembly, the U.S. delegation for the Helsinki Commission, as we call it here. And I brought up the Finucane case in Bucharest, which is where the Parliamentary Assembly was meeting, and made a very strong push to get the Parliamentary Assembly to embrace the public inquiry and to expose the truth and to try to get justice. The UK delegation reacted bitterly to my efforts, so much so that we used to have a meeting every year at the Parliamentary Assembly with the members of the Parliament, House of Commons, as well as the House of Lords. It was more of a social but a nice meeting that would take place, and they canceled it. They were so angry. And I remember saying to several of them, including the head of their delegation, if you have injustice in America that you point out, and you point out anywhere in any venue, and it's injustice, I'm all ears. You know, it's not a matter of some false sense of nationalism that should preclude any kind of criticism that comes our way, because we certainly, you know, whether it be slavery or other injustices that our legacy past, should you know, be accounted for. And that goes for the civil rights movement and some of the terrible things that happened there. There's no statute of limitations on burning down churches and killing people, and we all admit that. If they bring something up like that at the Parliamentary Assembly, I would be a co-sponsor of it to back them. But they boycotted it. And I'm wondering what the view might be among House of Commons and Lords that you're hearing with regards to this new effort. Are they embracing it? Are they saying, finally, at long last, we're going to get this right? Impunity and murder should be in no part of our operations? Or are we seeing a reprise of the year 2000 in Bucharest with the UK delegation?
The reaction overwhelmingly to the announcement, I think, has been to welcome it. Certainly through my role with being in Westminster, there is certainly more support within the Labour benches than there was under the Conservatives, and that's representative of the response or lack thereof that we were faced, even particularly over the past 4, 5, 6 years. There is the predictable criticism that you would expect to get from certain political quarters back home in Ireland, but it is something that has been welcomed, and it's a welcome with a caveat, with the caveat being you've done the good thing by making the announcement that you will establish this inquiry. Now, essentially, don't mess it up. You know, let's do it properly, and I think that's where people's focus has been. Obviously, an incoming government has many different issues to deal with, but it is part of a very deliberate attempt to reset and rebuild relationships between the two islands. Whether we have found ourselves on the right side of this decision being made because of that ability and intent to rebuild relationships, who knows? But it is a long time coming. It doesn't surprise me that you faced that in the early 2000s, because I think we've spoken before around the nature of the opposition that we faced is sometimes reflective of where we've been in our journey. So at the start, there was no such thing as collusion. Then possibly a few bad apples. Then it was very expensive to look at things like this. And then it turns into, well, it was an awfully long time ago. So there are different stages of the opposition that we have faced over times. That point blank refusal to even engage on the issue, unfortunately, is something that we faced as well as you. But that stubborn commitment, if I can phrase it and praise it like that, is very important and has all helped to bring us to where we are today.
Thank you, John. Just one final question, and Catherine and Geraldine, you might want to speak to this, especially given your expertise in mental health. I have often wondered how your family and your mom, Geraldine, how you have just overcome the lies, the disappointment, first of all, the atrocity that was committed against your dad and your husband, and to see people in very high places. How do you manage that mentally and emotionally? The fact that you have all persevered and prospered so well, have done so well, is extraordinary. It would have crushed so many other people and families, and yet you persist and are on the verge of finally getting an accounting, which will bring some closure. Obviously, it doesn't bring Pat back, but it does bring some closure. How have you done it, Geraldine?
Well, at the start, as was mentioned earlier, there had been threats made. When Pat went to police stations to see his clients, they would say, oh, we were told you're not going to be around any longer, and stuff like that. And I think at the time, Pat maybe felt these were more interrogation techniques to scare the client rather than the lawyer. But when Douglas Hogg made that statement in the House of Commons, it took on a whole different meaning. So when he was actually killed, there were immediate questions to be asked. And that's basically how it started. And it was very slow because information didn't come out quickly at that time. And I think it took about 10 years before I realised that this was not about the murder of one man, that it was actually a policy that was being employed over the whole of the country. And a lot of people were afraid, and there wasn't the representation. The organisations that are now available for people to go to for help were not there. So people used to say to me, keep going at what you're doing. You know, we wouldn't know how to start. We wouldn't want to start. We don't want to be public figures. But if you keep going and you get to the truth, then, we will know what actually went on. So based on that, how could you stop? Because not only would you not have some satisfaction in finding out for yourself, but you'd be letting a lot of other people down. So that's why I'm here now.
That's beautiful. Catherine?
I think, we appreciate your comments on how strong we are and how we've kept going all of these years. That's not to say that it's not difficult sometimes. We're here because, we're very passionate about the campaign, but it is something that we all have to manage on a day-by-day basis, really. And it is important that we manage our own difficulties around it, as well as dealing with the very public nature of the case. So we all have our ways of doing that. And personally, coming over here, whilst it's important, it is difficult, especially for me, to speak like this so publicly. It's not my job the way it is my two brothers. But I will balance that out whenever I go home by spending time with my husband and my daughter and doing all the things that I need to do to for my self-care, and that's a daily thing, really.
Would anyone like a last word? Michael?
Yeah, I think the experience is difficult and traumatic, but we, I think, have learned a great deal and progressed a great deal that has had an impact on our society. And I think feeling like you've been a part of that is cathartic. That it wasn't in vain, and that what you're doing means something. John and I are in a line of work where you find yourself representing people who you can see are experiencing many of the same things that you've experienced in your life. I've represented people who were bereaved in difficult and controversial circumstances in Ireland, not conflict related, but maybe just having gone through my own life's journey, I feel sometimes I'm able to maybe help them in a way that a different lawyer would not, because of what I've experienced in my own life. And it's nice to be able to take something that was extremely painful and use it to give something good and beneficial to another person, just by having a little bit of understanding and insight, and maybe even empathy with what they're going through. And I suppose that's one of the things that helps me get through it when it's difficult.
I want to thank you so very, very much. You know, as individuals and as a family, the Finucane family is an inspiration for what is good and honorable and just, and an inspiration to us all. And I thank you for that. Hearing's adjourned.